Have you ever put off asking for help about something because you didn't want to look like you don't know what you're doing? We'll talk about real answers to real questions about estate planning right now on The Law Works.
From West Virginia Public Broadcasting.
The Law Works is made possible by the generous support of the West Virginia State Bar, the Monongalia County Bar Association, and by a major grant from the West Virginia Bar Foundation, promoting public knowledge of the law in West Virginia. The West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and justice system.
One of the hardest things to do in life is planning for your own death. My guest is attorney Bruce L. Stout. Bruce, thank you for joining us. I think it's the first time you've been here.
That's right. Thanks for having me.
You wrote a book that I came across, Estate Planning in West Virginia, Real Answers to Real Questions. A book about things you should think about contemplating planning your estate. Why did you write this?
Well, my thought was that the vast majority of books that are written for people in terms of estate planning are written with a heavy focus on taxes, estate tax. And as a result, with the estate tax credits going up and up each year, it doesn't apply to very many people. There's a huge number of people in our state, as in every other state, that don't necessarily have an estate tax problem, but they still have issues about disposing of their estate and making sure that the people that they want to get their estate actually receive it.
I suppose we have to talk about estate taxes just a little bit. What is the level at which estates begin to be taxed right now?
Well, as only with Congress, that's not a simple question, or a simple answer. The bottom line is, in 2009, we were looking at 3.5 million. 2010, we supposedly do not have any estate tax at all, regardless of the size of your estate. In 2011, we're supposed to go back to a unified credit or amount of $1 million that you can have without paying any estate tax. However, there are a number of bills in Congress that seem to be moving towards a $3.5 million unified credit that we're going to have now. The interesting question, it seems to me, in 2010 is if you've died early in the year and the bill isn't passed till, let's say, later in the year, is Congress, which is going to be their goal, going to be able to make that retroactive? Or are the people that just simply happen to die at the right time going to be able to get a pass from estate tax?
Which is why we don't like to talk about tax issues, because they're incomprehensible.
Right.
So if somebody died in 2009, their estate was not subject to tax so long as it was less than $3.5 million.
Correct.
In 2010, if someone passes away, there is no estate tax. They don't have to worry about it this year.
Unless Congress changes it, makes the
Law
amount retroactive.
But in 2011, it's going to be something, but we don't know yet what.
Well, under current law, it would be $1 million. But again, most people believe that Congress will act this year, maybe as soon as next month, to make it a $3.5 million credit. So everyone under $3.5 million would not have to pay tax. If you remember, too, that you can double that credit for a husband and wife. So then, in effect, as long as you have the right kind of wills and divide the assets properly, a husband and wife can have $7 million and not pay any estate tax.
It would seem like estate taxes then wouldn't affect a great many people.
Correct. It's only about 5% of the public. So what I was concerned about, obviously I have clients in that category, but I also have clients that are not. And my concern was those people need to have some sense that, one, estate planning is important for everyone, and two, what are the initial questions that you need to think about before you go in and see a lawyer? I often find that people are somewhat immobilized by the unknown, and therefore they don't come in to see the lawyer to begin with. And oftentimes when they come in to see me, they have a high level of stress, which really isn't necessary. This book goes through in a question and answer format a number of the issues that most people ask. All of these questions are questions that I've heard in my practice, and I also have a questionnaire at the end that they could fill out before they go see the lawyer, which will allow them to expedite the process and therefore save money.
We want to mention we're talking about Bruce's book, Estate Planning in West Virginia, Real Answers to Real Questions. You'll find a link at the LawWorks website at thelawworks.org that will allow you to find information on how to get this book. You're not going to find it in bookstores, I don't believe.
Well, in fact, we are in bookstores. We just got into bookstores, trying to get into the chains, which is its own adventure. But we're certainly in private, mom and pop bookstores, and now we're moving in the chains as well.
Okay, good. It's a good book, and as Bruce says, it's a question and answer book. If you're internet savvy, we hear about frequently asked question lists or facts. The book is very much in that kind of format. Only, frankly, I think the answers are a little bit better developed in that way.
Hopefully that's the case.
I have seen many people over the years that come to me and say, we are thinking about having wills written, and frankly, I tell them, you don't need to have a will prepared. But those are almost invariably a couple with one child. The child is an adult, and that doesn't mean 18. Technically it does, but that means an adult of some years, 30, 35 years old. Because under the law of and I tell them, you don't need a will, because under the law of West Virginia, if you are modest assets, you have one child who is an adult, and you've only been married once with no children anywhere else, when you die, your spouse inherits everything. When your spouse dies, your child inherits everything, and you don't have to worry about estate taxes. You probably don't need to have a will prepared. Everybody else at least needs to answer some questions.
Absolutely, because everybody else may have a twist. Go back to your situation. What happens if it's a single, it's not the first marriage, but it's a second marriage, and one of the spouses has children other than the one child they've had together? Or let's say the child has special needs, some kind of autism or some other ailment that is going to make it important to keep government benefits. Or let's say that one of the two of them doesn't handle money well, and the husband and wife, we may want to have a trust to take care of that situation. So there are certainly simple situations that may not need a will, but the vast majority do. I think we would agree on that. And even if you don't have a will, I think you need to have a power of attorney, durable power of attorney for both the husband and wife in the event they become incapacitated, which of course can happen to anyone. It's not necessarily the norm in today's world that they can go to the hospital and just because of the spouse, they're able to make decisions or go to a bank by any stretch. They really need to think in terms of having someone on the power of attorney that's clearly in control to make those decisions.
So you really need to look at your impending death, and it's going to happen to all of us. It's not a question of if I'm going to die, it's
right.
A question of when am I going to die. And people are uncomfortable about talking about things
Absolutely.
like that. You're going to have to, as they say in the sports world, you're going to have to man up to it.
That's right.
You're going to have to confront it.
Right.
And it comes in two stages. What happens before you pass away and what happens after you pass away. Mm-hmm. So you're suggesting there are papers before you pass away or that would have effect before you pass away that you need to consider.
Right. And those would be a financial power of attorney so that if you become incapacitated, somebody can pay your bills, pay your taxes, make sure your investments are done correctly, make sure something as routine as your property taxes are taken care of. A medical power of attorney, so you name someone to make medical care decisions for you if you are unable to do so. And finally, a living will. A living will is the document, of course, that says if I'm terminally ill, persistent vegetative state, or a coma that I'm not going to come out of, that I don't want to go on. I don't want to have life-prolonging equipment put on me, and I recognize that I'm probably going to die.
There are specific directions that you can put in a living will. The basic form, and all three of these documents basically are form documents. It doesn't require a lot to tailor them to particular circumstances. But basically, the living will says, if I'm not going to recover, don't do anything extraordinary to keep me alive. Let me die, and let me die naturally. And a lot of people, that's exactly what they want.
Often clients refer to it as pull the plug, and it's in that kind of context. You know, it's interesting. People will say, do living wills really work? How did something like Terri Schiavo happen? Well, Terri Schiavo happened exactly because she didn't have a living will.
In fact, that's why we have living wills. It took a couple of cases like it. Terri Schiavo was a young woman who was in a long-duration coma, persistent vegetative state, we might say. There was raging debate about whether she was really dead or merely dead, whether there was some brain activity or not. And nobody could decide what to do. And they couldn't decide what to do because Ms. Schiavo had never said to anyone, I don't want to live like that, or this is what I want to have happen to me. And the courts, as courts do, just got completely bound up in all this and couldn't decide what action to take. It cost the family a gazillion dollars to go through it. It also cost them, more importantly, months of emotional trauma and agony.
And any shred of privacy was ruined. You know, that case actually ended up on the U.S. Senate floor where there were videotapes done. I mean, it's an abomination. And it all could have been prevented because, remember now, her simply telling somebody wouldn't have been enough. She had to tell them in writing. That's what Justice O'Connor said in one of her decisions on Karen Quinlan. So people have to
Karen Ann Quinlan was another case very similar.
Yeah. And the other thing that I'd point out there is a lot of younger people say, well, that's just something that they give to people in a nursing home.
The younger people are immortal.
That's right. But the fact is that younger people are really, in some ways, more at risk because if they get sick, they often can live for a very, very extended time, especially if they're in good physical condition. People that are much, much older will tend to develop pneumonia and die relatively soon. So young people very much need to have a living will and a medical power of attorney and a financial power of attorney.
In fact, Terri Schiavo, Karen Ann Quinlan were both young women who expected to live forever.
Right.
That's right. So you make those plans: living will, medical power of attorney, general power of attorney, or financial power of attorney. You'll frequently hear that referred to as a general durable power of attorney. And those words all have specific meanings, but don't worry about it. You need to have one of these things.
And that's all explained in the book.
Yeah, in fact, it is, yes. When I'm trying to decide, though, if I need to have a will, if I want to do anything more than just say, here, you take it all, as the law provides, I need to write it down in a will.
Absolutely. And one of the best ways to decide whether you want to have a will and whether what you want is consistent with the law of intestacy would be to look at the questionnaire that we have in the book and simply sit down and look at all of your assets. Do you want them all to go to one person? And also what happens if that person dies before you do? So a will is a starting point in terms of thinking, I want it to go to X, but what happens if X dies? We also need to think about that a will only controls the disposition of part of your property, what we call probate property. Assets that are in the decedent's name alone, assets that are held jointly with right of survivorship obviously go to the surviving joint tenant, oftentimes with spouses. But things like life insurance and retirement plans, for many people in this state as in other states, that's a large hunk of their value. Their assets value. And yet, oftentimes, all they'll do is name their spouse as the beneficiary. Well, again, what happens if the spouse dies before them?
Or with them.
Or with them, exactly. So they need to have a backup. They also need to recognize, and another unpleasant part of life, divorce. If they get divorced, yes, divorce does revoke the provisions of your will for your now former spouse. But if there are any provisions in there to her family, they still get them, which may not be what you want. And even more importantly, in terms of life insurance and retirement plans, it doesn't revoke those provisions. So you could have a very ugly divorce that went on for a couple of years, have a spouse named as the beneficiary, that doesn't get cleaned up for one reason or another during the divorce proceeding, the individual dies, and now the person he didn't want, probably the person the least person, the last person in the world he would have wanted to get his life insurance, is going to get him.
So if you're 20 years old and you're lucky enough to get a job with a substantial company that offers a retirement plan and life insurance benefits, and you think, I'm going to stay here forever, and you're lucky enough to actually be able to stay there during your working career, if on that first day of work when you're 20 years old, you name your wife as your beneficiary on either or both of those, and by the time you get to be 40 years old, you're contemplating divorce, you've forgotten that you have life insurance, you've forgotten you have a retirement plan, and that your spouse is your beneficiary, you may, a few years later, be leaving a lot of money to somebody that you hate.
Right, and that's part of what you discuss in the will process as well. Not just assets passing by the will, but assets passing by whatever vehicle. And, it's important not only to do a will, but to make sure it's updated. We just talked there briefly about the changes in the tax law, but there's also an amazing number of changes in your own life that occur, whether it be divorce, whether it be your children getting married, having now grandchildren for you, maybe your children divorce, maybe your daughter marries, and the last thing in the world you want is for that son-in-law to get any of your money.
That's the no good son-in-law that your daughter married.
Rule. Yeah. And so maybe you want the money for your daughter not to go outright, but to go in trust, because you're afraid that once it goes outright to your daughter, she's going to commingle it with her husband that you've never liked, and before long he's going to get his hands on it, and if they get divorced, he's going to end up with 50% of your money. And you'd rather have it go to your grandchildren after your daughter's death, and you can do that through the vehicle of a trust if you have a will.
Or you may die without a will. You're not married because you got divorced, but you have a couple of children. Your children will now inherit everything you had. If they're under 18, their mother is going to become the trustee of this. The law holds this money in trust, or presumes that it's going to be held in trust. It's called an implied trust. And the closest relative is going to be the person who manages it. That's your ex-wife or your ex-husband.
Right. And then not only is that a problem, but the other problem is that your children are going to get the money at 18. I have a son that's 17. If that happened to me and my son got the money at 18, only the local car dealers would be better off. It wouldn't go where I wanted it to go, that's for sure.
The sad fact of the matter is that you may become an adult at age 18, but you don't become an adult until much later.
Right. I think that's even more true than maybe it was 20 years ago.
Well, I have seen occasions over the years where the young 18-year-old man inherits or otherwise comes into possession of a lot of money, and it's gone instantaneously on cars and other things of similar nature. And unfortunately, and it sounds sexist to say it, but if you give a large sum of money to a young woman at 18, she not only has the opportunity to waste it, just as the young man did, but she becomes a target for men who want to prey on her.
Right, and not only that in today's world. If it was only that bad, it would be bad enough. But at least after the car dealers get their cut, at least your child can go on with their life. What I see oftentimes is young people who get money way too early from inheritances is they get into substance abuse. And when they do that, they may never come out of it. And in fact, one of the more current things is you can have a trust set up so that if they are on drugs, alcohol abuse, then you can hold the distributions, and the distributions only come to them if they can prove that they're alcohol or drug free. And now it will be allowed to pay for medical programs to help them, but that's a way to make sure that the money's not squandered. Another thing that trust that I think can be very effective is what happens if you have a child that just doesn't seem to be getting it together. One time I had a person who had a son who had an engineering degree. Didn't want to work. He worked in a rock band, and she said he didn't even work very hard at that. Well, we made sure that when she died, because this is what she wanted.
This is Mom.
What she wanted was that he would actually have to go out and get a real job. So we gave distributions from the trust as a multiple of 4 times his earned income. Earned income was somewhat of a new concept for him, so we had to go through that. But once he grasped that, he actually got a job and accomplished what she wanted him to accomplish.
So for every dollar he earned, he got $4
From the trust.
from the trust.
Right. But he had to earn it, which was what she wanted.
Now, you start talking about trusts. Trusts are hugely complex and very expensive to draft, right?
No. Trusts are not really that complicated at all. Trusts are as complicated, now, to be fair, they are complicated if they're set up mainly for tax reasons. But even those you can walk people through. The other ones are not complicated really at all. I mean, you say ages, let's say you have children, small children, you say a third at 25, half at 30, the rest at 35. And before that, we have income and principal for their comfortable sport, medical care, and education. That's not complicated. But it's sure a whole lot better to do that than to give it all to them at 18 and then they go blow it.
Yeah, the idea is to have somebody in charge of the money that your child or children would receive who's going to spend it as you would for them under similar circumstances.
That can either be a family member or a bank or a combination. It's not, let's say you're talking about a trust of $1 million and you say, well, we'll just let Uncle Joe do it because he's a nice guy. Well, but if Uncle Joe doesn't know anything about investments, is that really such a great idea? Maybe a bank would be better, but maybe you want to have some family input, so maybe that's where we bring Joe in. So one of the beauties about a trust is that by and large you're limited only by your own imagination. You can come up with almost anything that will work. That's one of the nice things about doing estate planning. If people get to me early enough, I can almost always solve their problem. Now if they call me on the deathbed, it may be a little tougher.
And you've undoubtedly had the calls to the hospital.
Right,
I've had those too.
Well, I've had the ones where the wife calls me and says, my husband died. And I say, I'm sorry. And I said, when did he pass? And she says, well, about 5 minutes ago. So, I have those too. But
we were talking about powers of attorney, general or financial powers of attorney and medical powers of attorney. Can I continue to act under those after my husband or my wife dies, because there are some things that need to be tidied up? He didn't write a will, but I've got the power of attorney, so I can take care of that, right?
No. The power of attorney terminates at death. And so what you have to do then is you have to be appointed by the court, county commission here in West Virginia, if there's no will, as an administrator. And the downside of that is you have to post a bond. Now, it's not hugely expensive depending on the size of the estate, but a lot of times I have found that people like the idea of a will, even in relatively modest situations, because they like the stability of because only by a will do you get to name who's going to be in charge of your estate.
You also get to nominate guardians for your infant children.
Which is absolutely critical. I've had situations where serving as a guardian ad litem, especially early in my career, I saw people that one person almost got a hold of a 14-year-old girl who we later found out had exposed himself to other young people. I mean, think of what that would have been like if he would have been guardian of that child.
And the law just kind of goes to the nearest relative and says, okay, this child is yours, raise him.
And you can't blame the judge who's trying to make a decision in a couple hours as to who should be the guardian. That's the parent's responsibility, and I think it's almost parental malpractice to have minor children and not take the time to name a guardian.
You've also got complex family relationships that involve marriage, divorce, children by different relationships, children being commingled into a family relationship where there's no relationship between the children. Wills are imperative to explain how to take care of that.
One of the things in the disintegration of the American family and the divorce and second marriages and so forth, of which I am a victim. Well, victims. I'm divorced once and I've remarried. I know that situation, and I think it's very important to think about how you feel about your stepchild, or have you adopted that child? In my situation, I've adopted one of my wife's children, but not the other one. But I don't dislike the other child. I just don't feel as close to him as I do my daughter now.
Well, there are situations where you may marry someone who has two children. One is an adult and one is not. You may well adopt the infant, but you wouldn't adopt the adult, or not
Unlikely.
typically, would you? And the children may have different needs. I want to talk.
But let me. One of the ways to get to that problem would be to, if you take the simple approach and just give everything to the spouse, then you are relying on your spouse to make the decision that you would have wanted to be made, and that may or may not be very realistic, especially if you die and she lives for another 20 years. She's probably going to connect more with her children than she is with your children. That's just a practical reality. What I would think about is having a will that puts all of your assets in trust for her. She benefits from those during her lifetime. And then when she dies, the assets pass to whichever children and whatever percentages you want. And she does the same. That strikes me as a far better result than just giving it to her and hoping for the best.
Which is what I've done in my case. Maybe I need to get your
That's
card
right,
before we leave here. There are all kinds of permutations, mixtures of these things, and each case is unique. I've heard some people come in and they say, well, here's my will. I copied it from my cousin's will. That's good enough, isn't it? And my blood turns cold.
Right. That's one of the things I stress with my students at the law school I teach in the estate planning course is your job as the lawyer is not just to be a scrivener, not just to take theirs and type it up and be done with it. You're supposed to ask the hard questions to make them think about, is this what they really want? And
Make
also,
a man up.
Make a man up and make them think about what happens in the event that their first named beneficiary or their first named executor dies before they do.
Bruce Stout, author of Estate Planning in West Virginia, Real Answers to Real Questions. I have read this book. I love this book.
Great.
We're going to have a link at thelawworks.org, our website, on how you can get your own copy of this. If you are hesitant about wills and estate planning, this is something you really ought to take a look at. Bruce, thank you very much for taking time to be with us.
I enjoyed it.
And thank you also for being with us. On behalf of the LawWorks, I'm Dan Ringer. Good evening. On the LawWorks webpage at thelawworks.org, you'll find a listing of recent The LawWorks show topics and additional information about this show's topic. If you would like to recommend this program to a friend, you'll find video of this program at thelawworks.org, and you can find previous programs on YouTube. If you would like to suggest a topic for a future The LawWorks show, or if you're a school teacher and would like to receive a copy of this program for classroom use, please send us an email to thelawworks@comcast.net.
The LawWorks is produced in cooperation with the West Virginia State Bar, the Mountain State Bar, and the West Virginia University College of Law. The LawWorks is made possible by the generous support of the West Virginia State Bar, the Monongalia County Bar Association, and by a major grant from the West Virginia Bar Foundation, promoting public knowledge of the law in West Virginia. The West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and justice system.
From West Virginia Public Broadcasting.